Hey folks, Dale Davidson here, Davidson Law Offices in South Georgia. You'll see the raccoon eyes. Had some beach and boat therapy this past weekend and really enjoyed it. Got a nice tan going on. But hey, hope you had a great weekend too. But hey, let's dive into our topic. I call this my Hatfield and McCoy's will caveat. Of course, there's a lot of people out there who are they feel that they've been slighted by mom or dad or grandparents because they didn't leave them what they thought they should leave them. And so here's kind of a representative case of that. So here we had a parent who executed a last will and testament at her lawyer's office, not this office, okay, but at her lawyer's office, in the presence of two witnesses, okay, and a notary public. So here in Georgia, it takes two witnesses and a notary. In this will, the parent left everything to the child who had been taking care of her for 1.5, 2 years, okay? So there's a little bit of maybe some undue influence issues going on there. Caretaker child, there's a lot of cases out there with respect to caretakers who are taking advantage of a parent. But in this case, it was handled at the lawyer's office before two disinterested witnesses and a notary. So the last will and testament contains what we refer to as a self-proving affidavit that said, before me today appeared Dale Davidson, who signed this will as his free and voluntary act, and for the purposes therein expressed, before Nancy and Billy as witnesses and Sharon as the notary. Okay, so that's a kind of a simplified version of a self-proving affidavit. And so what this does with the will, it says there's a rebuttable presumption. We're going to talk about the word rebuttable presumption here in just a minute, that the last will and testament was executed in accordance with state law. Okay, that the parent executed the last will and testament as the parent's free and voluntary act under no undue influence or coercion, and was of sufficient age, legal age, okay? Which is 18 in most jurisdictions. All right, so several months after the parent executed the last will and testament, an estranged child comes into play. You knew this was coming, okay? So an estranged child comes in, finds out about the will, takes the parent to the lawyer's office, picks up the will, okay, and they leave. So then, whether it was, don't know if it was days, hours, minutes, weeks, the estranged daughter brings back the will. And guess what's on the will? A handwritten note says, "I hereby revoke this will, signed parent." The parent passes, okay. So now the caretaker child takes the will, sees this writing on the will, and goes to probate the will. Well, the now estranged child says, wait a minute, you can't probate parent's will because, first of all, she was coerced into signing this will in favor of you, okay, because you were the caretaker child. Now, remember the presumption that the last will and testament was validly executed, okay, by that self-proving affidavit. So we've got that presumption on our side. So now that burden of proof goes to the child who is saying the will was revoked to actually prove that it was revoked, okay? So the estranged child now has the burden to say that, hey, caretaker child, you unduly influenced parent to execute this will, therefore it's not valid. But that's not what we really want to talk about today, but that was one of the issues that we discussed at this trial. So issue number 2, and this was the big one. Was the last will and testament validly revoked pursuant to state law? When parents said, I hereby revoke this will, signed parent. That was the big question. Okay. Now, I will say that 80-year-old lady or man probably won't use big words like hereby, okay? But anyway, that's a side note. So the law says that the will has to be destroyed or obliterated. So in this case, clearly the last will and testament wasn't destroyed because it wasn't ripped up, okay? As a general rule, if somebody's coming into my office and we're redoing a will and they have an original will with them, we have them tear the will up in front of us. And then we put the torn up will in the shredder. So we've actually seen the destruction of the will. That is the physical intent of revoking that previous will, because we've just now executed a new will. So then the question is, was this last will and testament obliterated? Well, what does obliterated mean? So there were no words that were crossed out, no words that were scratched out. There were no lines, big X's on the paper. There was no blackout of names. There's no blackout of any words. In fact, the words, "I hereby revoke this will," signed parent, was actually on the margin outside of any word, so it didn't even touch any word, any typewritten word, okay? So it wasn't blacked out. There were no illegible words, okay? There were no smudges, smears, anything like that, okay? So it was, you could still read the will clear as day. So the question is, again, is it obliterated? Let us know what you think. Do you think that just writing, "I hereby revoke this will," without anything else, is sufficient under law? Do you think that's sufficient enough to have revoked this will? And I will give you the answer in another video in a couple of weeks. So the other issue here, if the will was not destroyed, okay, and if it was not obliterated or any material portion thereof, did the parent have the requisite mental capacity to destroy, obliterate her will or his will? We argued in this instance that no, the parent did not have that requisite mental capacity. That burden was on us, okay, to prove that, because until somebody's in a court of law and the probate court deems them to be not competent to make important decisions regarding their person, or not competent to make important decisions regarding their property or their finances, they're deemed to be able to do whatever they need to do. So now we have to offer evidence that mom or dad was not competent in this instance. So how do you offer evidence that somebody's not competent after they're passed? Well, medical records, okay? So the law says that we can offer evidence of medical records that says that the parent did not have the mental capacity to make important decisions regarding his or her property and make important decisions regarding his or her finances immediately before, during, and immediately after this supposed revocation. But what's interesting in this revocation hearing that we had is the revocation wasn't dated. So we don't know when the parent revoked. So in this instance, we had to offer 2 to 3 months worth of medical evidence showing that after the parent executed the will, somewhere down the line, 2 to 3 weeks, whatever, that things happened, and so therefore now the parent was not competent to make those decisions. So the parent was not competent to revoke or obliterate the parent's will. Again, tell us if you've had any experience with this. Tell us what you think. Do you think the parent's will was obliterated? If you think the parent's will was obliterated, do you think maybe the parent had the requisite mental capacity to revoke the will? There's a lot of moving parts in these will caveats. This was a very difficult one. That's why I call it the Hatfields and McCoys, because nobody could agree upon anything. There was a lot of yelling and screaming and gnashing of teeth and things of that nature. And sorry to say that this family is probably never going to get back together over this. So my advice to you as a parent or grandparent or whoever, if you've got children, more than one child, usually this happens, doesn't happen with a single, an only child situation, but if you have children, make sure that everybody understands why you are doing what you're doing with your property. You have the power and authority to do whatever you want to, but just make sure that it's clear that I'm giving Dale all my property because he took care of me for the last 2 years, or I'm intentionally not leaving Sharon anything because she's been estranged from me for whatever those reasons are. Make sure that people know them. Okay, write them down, put them in the will. If you're going to intentionally disinherit somebody, you don't have to be mean about it. You could say something to the effect that, hey, I'm intentionally not leaving Dale anything under this will for reasons which seem valid and controlling to me. Not because I don't love Dale, but for other reasons which are known to me. That's good enough for the court to say, guess what, Dale? Sorry, pal, you're out of luck. But you just got to do it right. Okay, be smart about it. So I hope we have given some insights into the Hatfield and McCoys, not the ones from the Old West, but certainly the ones here lately that we have been seeing in the courts. Hopefully this is not your family. Pray that it's not. If you have any questions, please leave us some comments below. Of course, always like and subscribe. We're here for you to help educate you because without education you can't make informed decisions. But that's what we want you to do, is make some good informed decisions so that your family doesn't turn out like the Hatfield and McCoys. So until next time, be blessed.
No more whiskey, I'll have a Coke. Catching bass on an old fishing boat. One more story from Grandpa Joe.